Welcome to Shenkman Education. My name is Marty Shenkman. The topic for this video clip is what happens when you die without a will. A will, I'm sure everyone knows, but we'll just say it is a legal document that you sign that has provisions governing, stating what happens with your assets. If you have a minor child, naming a guardian, appointing an executor or personal administrator to manage your estate. You generally put wills in writing, typed as a formal legal document. Laws may differ from state to state, but in general, you'd probably want a notary or are required to have a notary and 2 witnesses on the will. There's certainly some exceptions. There's a concept called a holographic will, which is a handwritten will, which in limited circumstances can be accepted, but don't rely on it unless it's really an extreme situation. And the rules for that also differ state by state. Many people hear online that they're supposed to have a revocable trust, but gee, then why do I need a will? You still need a will because if nothing else, you may not have gotten assets retitled to the revocable trust. So there's a lot of background and other issues and considerations to the discussion of what happens when you die without a will. But let's assume that you don't have a will and you haven't done revocable trust and other planning. What happens? First, and I think this is a significant misconception that most consumers have, if you have or don't have a will, many, and in some cases all of your assets may pass or be transferred by what's called operation of law. So for example, if you have an insurance policy and you name a beneficiary, that insurance policy's proceeds go to that person you've named. It doesn't matter what you say in your legal documents or your will, rev trust, etc. If you have a bank account that's joint with somebody else, it goes to the joint owner. If you own your home as joint tenants or tenants by the entirety with a spouse or joint tenants with a kid or niece, nephew, whoever it may be that you have it jointly with, it goes to them. If you have bank accounts that are in trust for ITF, pay on death, POD, they go to that person. So the first question of what happens when you die without a will is really a broader question of planning. And by the way, all the things that I've just kind of rattled off about holographic wills, the requirements for wills, revocable trusts, how assets are owned, that's the reality of how estate planning needs to be looked at. So when you're evaluating the question, what happens when you die without a will or with a will or a revocable trust, it's much more complicated than many people understand because you got to actually get into the details. Too many people get taken in by the idea of a magic bullet. If you do this, you sign this form or you buy this document online or a lawyer does such and such for you, you've solved your problems. You haven't. Even if you get a great attorney and he does a great will for you, if you haven't addressed the ownership of assets and a lot of other things, the planning is not going to accomplish what you want. So when you die without a will, you need to have typically a proceeding in court, surrogates court, probate court, different names in different areas, where a designated person, and because you don't have a will, that person is going to be determined by statute, by state law, which is why you should prefer to do a will than rely on a default state statute, will designate a sequence of people. It could be spouse first, then kids in age order, etc. But it's going to designate who gets the authority to administer the estate. And you may be able to have a court proceeding to try to change that under certain circumstances. So you got to go to court, surrogates court, probate court, and get what's called in different names in different states, letters testamentary, but it's an official recognition of that person that the state law says will take care of managing your estate if you don't have a will. And that, by the way, is why you want a plan. You don't want that. Next, state law has default provisions for who gets your assets. And that's often not what you want. So for example, if you're married and have adult children, it may be your spouse gets 50% and the kids split 50% or some other arrangement. But that's it's almost never what people want. It's just what the state provides. So if you die without a will and you did nothing, there's at least some order to what it is. You have to find out exactly what state statute says, state law says, about who's going to be the administrator of your estate. They have to get appointed, and then assets have to get divided based on that. Now, which assets will get divided goes back to what we just talked about a minute ago. A lot of the assets you have may not be what's called probate assets, meaning assets that pass under intestacy, which is the legal term when you die without a will. Because if you have a joint account, an insurance policy, all the things we just talked about, they're going that way, not by state law. State law will only govern the assets that are part of your probate estate that the court has administrative authority over. So when you die without a will, those are the procedures to go through. And one of the most important take-home lessons, if God forbid a family member's died and they don't have a will, this is what you have to go through. Think broadly, look at the title of the assets. Another point, and forgive me for just bringing this up at the end, but there's a concept called disclaimer. You can legally file a document with the court saying, I renounce, I disclaim the right to a certain asset. So let's say you die, a family member died without a will, and the state default statute's not what they want. If family members will cooperate, they can disclaim or renounce certain assets that would come to them, and maybe they'll go to the other people. So renunciations, disclaimers is a way to rejuggle assets to get them where the family wanted if state law doesn't provide for that. So dying without a will is not optimal. If a family member did, I've just described a lot of the process that you need to go through. If a family member has not died and they don't have a will, there's a good incentive to get one. By the way, if you have minor children and you don't have a will, the court's going to appoint a guardian for you, and it may not be who you want. If you have minor children, don't make the mistake of not having a will. Do a will, get a guardian appointed, and a successor in case something happens to the first guardian. So hopefully that will give you some insight on what to do, but you really want to proactively plan. And not a sales pitch, but you know what? Hopefully the details of what I've given you help you understand that dying without a will is complicated. If you have a loved one that did, I wouldn't try doing it on your own. At least at minimum, hire an attorney that specializes in probate and estate work, and have them at least give you a roadmap of the options and different things you can do. You don't want to find that you've done stuff and assets go a certain way, which is not what people want, and now it's even harder to undo. Thank you for joining me, and please keep in mind that all the information on the video clip is for educational purposes only. Don't take any action without appropriate legal guidance. Thank you.